We will hear argument first this morning in Case 24-808, Coney Island Auto Parts Unlimited versus Burton. Mr. Ginzburg.
Thank you, Mr. Chief Justice, and may it please the Court. Historically, judgments entered in the absence of personal jurisdiction have been described as a nullity, utterly void upon entry, lacking any legal effect, and odious to due process. Accordingly, they have routinely been vacated without reference to any specific period of time or deadline, and courts have noted that it is per se an abuse of discretion for a court not to vacate a void judgment. In this action, the lower courts did not determine whether the judgment was void. Rather, they held that Coney Island took too long to bring its motion for vacatur in violation of Rule of Civil Procedure 60C1, which requires such motions to be made within a reasonable time. This Court has never had occasion previously to consider whether Rule 60C1 applies to judgments void ab initio or the definition of reasonable time. We respectfully submit that the lower courts erred because, as a matter of logic, Rule 60C1 cannot apply to judgments void ab initio. And the reason for that is that if the judgment is void immediately upon entry and remains so for all time, there cannot be a time after which the judgment cannot be vacated, because a judgment that is void ab initio cannot suddenly spring to life, become active and enforceable through the passage of time alone. To harmonize the doctrine of void ab initio in a reasonable time, the Court may find, as it has in the past, that a defendant believing that a court lacks jurisdiction may elect to ignore the proceeding, suffer the default judgment, and then collaterally attack that judgment when the judgment creditor attempts to enforce it. Enforcement, however, must be adversarial in nature, or actually invading a personal interest, for example, a contempt proceeding or seizure of a bank account, such that ignoring it would be tantamount to a waiver of a known right or acquiescence in the judgment. If enforcement were defined as any action at all trying to collect on a judgment, such as mailing post-judgment discovery, then it amounts to that post-judgment discovery essentially acting as a supplemental, unauthorized process, because the mailing itself would commence the time period, the expiration of which would cause a subsequent application for vacatur to be denied as untimely. I welcome the Court's questions.
So you're not arguing that your motion, your 60B motion, was filed within a reasonable amount of time?
We believe, Your Honor, that there is no reasonable amount of time within which a judgment that is void ab initio can be vacated.
And how is void ab initio different from the grounds listed in 60B, the judgment is void, that as a basis for the motion?
We believe, Your Honor, that a 60B4 applies to both void judgments and voidable judgments. And so when a judgment is voidable, there is no reasonable time limitation, because at that point the court that had entered it had jurisdiction, and for some other reason the judgment should be held void, as opposed to a void judgment which has no legal effect right from the beginning.
So how do you respond to Respondent's argument that you're conflating the merits with the timeliness of the motion?
Well, we believe, Your Honor, that if a judgment is void ab initio, there is no timeliness aspect that would that should cause a court to not vacate that judgment.
Suppose a district court issues a judgment that is void ab initio, and the party against which the judgment is entered waits a year before filing a notice of appeal. Would the Court of Appeals be obligated to entertain that appeal?
I think it would, Your Honor, because at that point the appeal, the filing of the notice of appeal is tantamount, or is not tantamount, would require an appearance before a court, and would result in the appearance before the court would result in submission to the jurisdiction of that court.
I mean, that does seem to be the logic of the idea of a judgment being void ab initio, and we addressed that last term in Hewitt versus the United States. Not a case that it's a criminal case, but still, we talked about void ab initio, and we said if a judgment is void ab initio, it's as if it never existed. It was erased from the historical record. So what you're saying does follow from the logic of that. But doesn't it seem strange that the appellant would have an unlimited amount of time to appeal from a judgment that's void ab initio?
I think even a void judgment can be given effect if the defendant or the judgment debtor acquiesces to the court's jurisdiction. And so if, for whatever reason, the judgment debtor believes that there is no basis for the appeal, the filing of the notice of appeal establishes jurisdiction and results in a waiver of the opportunity to file a Rule 60b-4 motion.
What about fraudulent judgments? Do you think that they can be challenged at any time as well, or there's no ground on which they can be reopened?
Well, I believe fraudulent judgments are covered by Rule 60b-3, which requires or which must be filed within 1 year. And so that timeliness aspect applies through Rule 60c-1 as well as Rule 60b-3.
Well, I guess I'm a little concerned about the potential collapsing of the merits with your argument in this case. Because your argument, as Justice Alito pointed out, is premised on the fact that this judgment is actually void. But obviously, the person who benefits from the judgment would say it's not. And so some court somewhere, I think, would have to resolve that. And I guess the question is, why should you be able to make that kind of challenge without any sort of procedural limitation in terms of time? Someone has the judgment who's benefited from it, and they are living their lives and thinking everything is fine, and under your rule, that can be upended at any time on the basis of your claim that the judgment is void. Don't we have procedural rules that sort of just limit your ability to make that claim and really don't speak to the issue of whether or not it's actually void? You just have to make that allegation within a particular period of time.
Justice Jackson, I would say that void judgments or judgments void ab initio are within a separate class. And so the Constitution requires that void judgments not be given effect.
Right, but what if we don't know whether or not this is a void judgment? I mean, that's the issue, right? That's the merits claim that you are making when you file this motion. And someone has to decide it. And I guess my question is, what is a court supposed to do? 10 years later, you pop up and say this was a void judgment. Doesn't the court have to decide whether or not it's a void judgment in order to determine whether or not you have filed this in a timely fashion?
Well, yes, obviously you have to make a motion and you have to convince the court that the judgment is void. But if the judgment is void from the get-go, then there cannot be a time limit setting apart res judicata or waiver when that judgment would suddenly spring to life.
I guess my problem is that usually we would decide whether or not you are able to file the motion as a threshold matter before we get to the question of whether you're right about the motion. And you seem to have those inverted.
Well, I think, and to go back, I would say that obviously you have to file the motion. You still have to convince the court that the judgment is void. But there cannot be a time after which that cannot be done. Because if the judgment was a nullity from the beginning, then there is nothing for the court to do other than to determine whether it is void. And if it is void, then the decision of whether it is void is essentially a confirmatory ministerial act.
Mr. Ginzburg, I just have two clarifying questions.
Yes, Your Honor.
First concerns one of Justice Thomas's question. I know you resist the notion that C1 applies and the reasonable time limit, but you didn't make any argument under that here, as I see it. So we don't have to decide in this case whether if C1 applies, you did in fact proceed in a reasonable time. Is that correct?
Yes, Your Honor. We believe that, again, if a judgment is void ab initio, then the reasonable time.
I appreciate that, but the alternative argument is not before us that you complied with C1, right?
That's correct, Your Honor.
Okay. And then if we were to rule against you, and I know you resist that,
Yes.
would your client be able to file a D motion, collateral attack to the judgment?
Justice Gorsuch, the
D1.
case law on Rule 60D1 is a little sparse.
I'd agree with that.
So I would say that the usual scenario in which a Rule 60D1 motion is filed is when somebody has run out of time to file a motion under Rule 60B1 through 3. And so I think if the court were to disagree with Coney Island's position, then that would be the end of the case because, well,
You
I guess
really want to give up the D1 argument?
I guess it would depend on exactly what the court's holding is. So if...
How would you have us write it to preserve that option for you?
I guess I would request...
if you want to preserve it.
I would always want to preserve it. But I would write it respectfully. I think the court should write it as saying that the reasonable time limitation in Rule 60B4, the reasonable time limitation in 60C1 does apply to 60B4 motions, but there is also a time, there is otherwise no time limit under Rule 60D1.
If you had this independent collateral action, whether under 60D1 or imagine a world without 60B, and you can just bring an independent collateral attack on the judgment, would the defense of latches apply, or would your reasoning there be that, no, there just can never be any limitation, no statute of limitation, no latches defense from the other side if a judgment is void ab initio?
I would say, Justice Barrett, that yes, that there is no latches argument to be made in connection with a void judgment, in the void in the pure sense of the term.
What do you do with the history? I'm sorry. What do you do with the history that some state courts for decades have applied latches to just this situation? Doesn't that defeat your common law understanding?
I believe, Your Honor, that if we were to, or if the court were to rule that latches cannot apply to a void judgment, then that would...
Yeah, you're asking us to rule that way because you say there's a common law. But if there isn't a common law, because there were latches applied by some courts, not all of them, but some, doesn't that defeat your argument?
I would say, Your Honor, that it would not defeat the argument, because if the court were to find that a void judgment cannot be given effect for due process
You're going
reasons.
around in a circle. We can only find that if there really is a common law rule and Rule 60B doesn't override it, because common law rules can be overwritten by 60B.
Correct. And so
if we look at what the advisory committee said when it was creating 60B, was that it wanted to, because the existing rules in common law were quote unquote confusing, one of the purposes of the amendment was to clarify the rule so that the federal rule will be controlling. So what do we do with that?
well, because the enforcement of a void judgment, even to overcome latches, would require a violation of due process.
Could Congress write a rule that says exactly what you want? Even void judgments need to be filed within a reasonable time. Does Congress have the power to do that?
I was going to say, Your Honor, I don't think Congress has that power because the Constitution, because of the Due Process Clause. And so if the court were to find in Coney Island...
But you gave up constitutional arguments in your brief.
I'm sorry, Your Honor?
You gave up constitutional arguments in your brief.
I think we didn't give up constitutional arguments, we gave up an argument that Rule 60C1 itself is unconstitutional. But the Due Process Clause still exists, obviously, and so we would say that the Due Process Clause would require an overriding of a latches argument.
Thank you, counsel.
What falls within the category of void judgments in your mind? Like what are the range of things that are in the category?
It would have to be, and the court has spoken on this several times, it would have to be a judgment that was entered in the absence of subject matter jurisdiction, personal jurisdiction, or some other defect that would cause a similar effect.
Some other defect, do you have any others that you know, offhand that fall within that same category?
Potentially bribery of a judicial official, or some other defect that goes to the very heart of the court's power to hear a dispute.
But your argument would necessarily mean that any time limits as to raising a personal jurisdiction issue would be invalid. Is that correct?
Yes, Your Honor.
Okay.
What have the
I was just going to say, your friend on the argues that you're conflating two concepts, whether a void judgment can become valid, I suppose in some abstract sense, and what the procedures are for vacating a judgment. I guess you assume that even if the judgment that it must be vacated. On the other hand, I think the argument is that I don't know whether it's in an abstract sense, you consider the judgment, even though valid, it can't, under the normal procedures, can't be asserted. I mean, sort of like a statute of limitations, I suppose. I mean, you don't necessarily have to suggest there's anything valid about what, you wanted to challenge, but it just can't be raised given the statute of limitations.
I would say, Mr. Chief Justice, that if the procedural aspect of it is the filing of the motion, meaning that it still has to be filed according to the Federal Rules of Civil Procedure, has to be filed appropriately, has to be filed in the correct court, has to be signed under Rule 11. But I don't think that the reasonable time limitation is a potential procedural bar.
But the Rules of Civil Procedure, for example, say, that when a suit is brought and you have a personal jurisdiction defense, you have to raise that defense before the answer or, with the answer if you file an answer. There's some sense of like when you're supposed to file your personal jurisdiction defense, and if you don't, and if you wait forever, it's lost. Would that also be, we should basically say that rule is unconstitutional, a violation of due process?
No, Justice Kagan. In that case, if somebody were to file a motion under Rule 12b, they would be submitting to the jurisdiction of the trial court, and the trial court's decision would then govern the proceeding. Same with an answer. If somebody files an answer or even makes an appearance, they are submitted to the jurisdiction of the trial court, and they have a direct appeal if they disagree with the court's decision.
What have the courts of appeals and the commentators, Moores, Wright, and Miller, said about this question, whether there's a reasonable time limitation on seeking relief from a judgment that's void ab initio?
I think they have almost universally, the courts of appeals have almost universally, and the commentators have held that there is no, or the reasonable time limitation does not apply to a void judgment in the purest sense of the word, such as lacking personal jurisdiction or subject matter jurisdiction. The court has no further questions.
Thank you, counsel. Anything further? No. Thank you, counsel. Ms. Blatt?
Mr. Chief Justice, and may it please the court. The petition asks whether Rule 60C1 imposes any time limit to set aside a void default judgment. The answer is yes. The plain text requires that B4 motions be filed within a reasonable time. The phrase reasonable time does not mean any time. First, any time would include an unreasonable time, the exact opposite of reasonable. Second, by definition, reasonable means within just limits, not whenever. Third, a reasonable time means courts actually consider the facts of an individual case. It doesn't mean the move-it wins regardless of the facts. Fourth, had the drafters intended no time limit based on the grounds for relief, They easily could have placed void judgments under 60D, which has no time limits. Notably, D3 allows relief from judgments at any time for fraud on the court. The 3 courts below ruled petitioner's delay was unreasonable. The Court of Appeals stated, quote, Coney Island has not argued that it brought its motion within a reasonable time. The district court said the delay is unreasonable and Coney Island offers nothing to justify the delay. And this from the bankruptcy court, Coney Island has not even contended that the delay should be considered reasonable. I welcome questions.
Is there a way to challenge a void judgment beyond Rule 60?
Well, we don't think so based on the text of the rule and the history. The rule itself is pretty expansive. It says it is the way to get relief from a valid judgment, and the history is pretty clear. The advisory committee notes, which are codified, says it's obvious that this is the only way to get relief. We're trying to, close the door. The text of Rule 60E abolishes all the common law writs and remedies that were used to get relief. And we would rely, for those who care about this kind of stuff, the advisory committee chairman said there's no way left to get relief other than Rule 60. I mean, you don't have to decide that, and 60D has the one independent action, so they did leave that safety valve. That was very important to the drafters, that there's always an independent action. This court in United States versus Beggarly has said Rule 60D independent actions are reserved to correct gross miscarriages of injustice. So there is that Supreme Court case that says that. And the rule committee note says that latches applies to those kind of actions.
I want to be clear, Ms. Blatt. In this case, we don't have a question, although the Sixth Circuit acknowledged it, about whether the reasonable time period should only start when enforcement is attempted, correct?
Correct.
And right, because that seemed to be a part of your opposing counsel's opening argument, that somehow it was reasonable because...
Yes, and I mean, we think the question presented forecloses that, but we do think that at the time of enforcement, it could be quite reasonable to wait. Here, though,
but you do agree, there are many, many judgments entered, some with or without notice, but somebody might find out about something, no one's ever tried to enforce it, and why spend the money getting a lawyer? We don't want to encourage.
Right, that's what I was saying. I think it might quite be reasonable to wait until the time of enforcement. That might be the first time the person's ever heard of it. The person might have reason to think the judgment was never going to be collected. And most importantly, there may be no prejudice from whenever the movement filed. So we would just think a district court would have wide discretion. I would say that this case is kind of the poster child of why you can't really say enforcement, because it's conceded in 2016 that the trustee was trying to enforce the debt and then spent 7 separate attempts and thousands of dollars to get to the point of seizing the bank asset.
But that's an issue that a court below will have to address in another
No,
case.
because they've all conceded that it's
right.
reasonable. But yes, in any given case, prejudice would be considered. I think Justice Jackson made a very good point. The debtor, Vista Pro, filed the allegedly improper service. The trustee comes in, sees a valid judgment on its face, has no reason to think there's improper service, doesn't even find out that there's an alleged improper service until 5.5 years after the fact, when it's way too late. Had the judgment debtor just said at year 1, hey, there's improper service, they could have redone the service. So these are the kinds of arguments that would be considered had the other side tried to offer a justification. But I do think Justice Jackson makes that good point that there might be prejudice if the person has no reason to think the judgment's invalid and is, claiming please pay in a bankruptcy estate, just wasting money trying to go after a judgment debtor that should go to creditors.
Ms. Blatt?
Sure.
The petitioners here raise a Rules Enabling Act argument, but only in reply, so you didn't get a chance to address it in the briefs. Do you want to take a moment to focus on that here?
Sure. As I understand the Rules Enabling Act, it can't enlarge rights, but I think that's another version of, well, you're giving effect to a judgment that by hypothesis might be void, kind of spring to life, and I think you quite nicely said, there's just a procedural bar that you have to go through to get your right to argue that it's void or get relief from it. So I don't see any problem under the Rules Enabling Act. It's just not expanding any right. It's just a filing requirement that you have to file within a reasonable time.
Mr. Ginzburg says that almost all the courts of appeals have decided this question against you, and the leading commentators take the opposite position. How do you account for that?
So I think that's correct. I think these courts were writing, either now or at the time in a way that they were comfortable not following the literal text. Some of them acknowledge that they're not following the literal text, and this is just not consistent with the court's modern approach. I will say that most of these courts, at least 5 of them in the dissent, trace back to this D.C. Circuit decision from 1962, Austin versus Smith, that just didn't even mention Rule 60C1. But since, the coming of Justice Scalia in 1986, the court has taken just a different approach to statutory interpretation. And we cite an example of, I think it's U.S. versus Brogan, where all the courts of appeals had ruled 1001 gives you a right to lie, and this court just said, we're going to overrule that. And I think just last term you ruled against a case I argued when all the courts had gone our way.
Well, speaking of last term and lost causes, what do you say about Hewitt and the idea that a judgment that is void ab initio never existed? We can't see it. It doesn't exist. It doesn't exist.
Yeah.
So doesn't that lead to the conclusion that was drawn by all these courts of appeals?
No, and here's why. In addition to it's conflating the grounds for relief in 60B, fraud by the opposing party, and you've already paid the judgment, you've already paid it. How can you make me pay it twice? And the example we give in the brief, and I think it's quite instructive, is the area of preclusion. This court has already said that courts can give effect to void judgments, even concededly void, because if a party unsuccessfully challenges subject matter jurisdiction, they're barred by res judicata and collateral estoppel. And if it's concededly, on its face, it's issued by the Court of Clowns, you have to give effect to the judgment based on res judicata. Now, I will say, if you have a Court of Clowns example, you could probably get rid of that under the independent action for gross injustice.
Well, then what should we say about void ab initio, in our opinion? Well, it doesn't really erase it from the annals of history. It has, that's an overstatement.
It's not an overstatement to describe fraud on the court or fraud by the other party or void ab initio. That's the grounds when you get into court under Rule 60. That's the procedure where you get relief from that judgment. The whole concept of Rule 60C assumes that there are quite offensive judgments, and it's giving you relief, but there's either a 1-year time limit, a reasonable time limit, or no time limit, and this void judgment falls in the reasonable time limit.
Well, if suppose the reasonable time limit applies, and I know maybe we don't have to decide what that means here, but if we were to decide that, would you agree that there should be a lot more flexibility with regard to the reasonableness of a filing when what is being contested is a judgment that's void ab initio?
No.
You don't think that could?
I think a default judgment might. I think a default judgment just raises implications. You need to hear of it, but just I think, at least the way the rule's set up, maybe how void it is somehow bears on why you took so long. But generally, why you took so long, it goes to, why'd you take so long? When did you know of it? Did you ever, was it a burden because, you didn't want to go all the way and file this motion? And also, is prejudice arising? But sure, reasonableness is an abuse of discretion. And so, of course, a court can basically do whatever it wants, assuming,
And do you think there's any category of cases in which a reasonable amount of time can in fact be any time?
No. That's infinity. So,
that there's some category of cases that because of some feature that they have,
no.
that whenever you raise it, it will be considered.
No, by definition, it's conceiving that there could be an unreasonable time and any time. Now, that being said, you could say, I'm happy to give you any number, 1 billion years. I'm just not going to concede any. because it has to be reasonable. And in the bankruptcy context, there's almost always going to be prejudice because the trustee is trying to close the estate. And I'm talking about notice. This is a person who has notice, and there's prejudice creeping in. But if there's no prejudice, then, I wasn't going to say any time, but a lot of time. Most people get a default judgment once they know about it. Certainly if they're sophisticated, they try to get rid of it. If they're unsophisticated, then sure, you're not going to make the person hire a lawyer. You just wait, whatever's reasonable. I mean, that's.
So your concept of reasonable time, it seems to me, carries with it some idea or consideration of the prejudice to the other side. Is that right?
Well, prejudice to the judgment creditor, and I just think you could reasonably take into account the burden on what Justice Sotomayor was saying about, did the person lack resources? I think that's certainly.
And notice.
Oh, yeah. So definitely, we think due process requires notice. Absolutely. We just think it's due process notice, which is actual or constructive. In other words, you can't hide and go, travel to the moon and avoid notice if the person is, doing all the things that the due process clause requires to give notice. But here, notice is conceded, I think, 6 times over because the trustee kept trying to do it.
Well, suppose somebody who's never left New York City, never traveled west of the Hudson, never done anything on the internet, never bought anything by mail, receives a judgment issued by a state court in Montana. And this person doesn't have a lot of money to hire a lawyer and says, what is this? I've never been in Montana. I don't know anything about this lawsuit. I never was served. I'm just going to ignore it. Wouldn't it be reasonable for that person to have more time to seek relief from this judgment?
Yes, as I was trying to concede a lot with Justice Sotomayor, but I don't think Rule 60 applies to state judgments. I think you got to go to the state court.
District judgment.
Yeah.
District court for the District of Montana.
Sure, there might be a lot of reasons where there's just no reason. Like you got a default judgment, you hear about it. I mean, if it's worth a lot of money, I might get scared and call a lawyer. But if you have no reason to think, they're never going to come after me. But when you know someone's coming after you, you probably should act. But if there's no prejudice, we don't have a problem with, at the time of enforcement, loosely defined, which would be the judgment creditors trying to collect on the debt. If I could just turn to just history really quickly. I do think, the plain text obviously overrides the history. Rule 60E's text says we want to get rid of all the common law remedies. But we do point out just 3 factors in the history that shows it wasn't uniform, and all 3 of those factors, ironically, are present here. The first is, we cite at note 2 of our brief, many courts held that these judgments where there's improper service had to be filed within a reasonable time. So that's, I think, that's kind of what Justice Jackson was talking about. The judgment on its face looks pretty valid. So parties not all parties, but some courts said they had to act within a reasonable time. And then the second was laches, that Justice Sotomayor also recognized that laches was a defense. And then finally, which is this case also, in the bankruptcy context, courts would not vacate bankruptcy court judgments when reliance interest had vested. And we would say, the trustee is an innocent party here and had no reason, and this really could have been fixed, would not have had to spend all that money had the judgment debtor just said, you need to reserve me. And instead, 5.5 years went away while the estate was being drained. I got you all. Oh, and one last thing for Justice Kagan. Espinosa defines the void judgment. It's a little odd, the definition. It said certain jurisdictional defects, but it didn't say what they were, and any judgments that were lacking notice and opportunity. So I think they were talking about, I'm not sure what the certain was, but I think they're also saying if it's due process, you didn't have any notice or opportunity, that's void. And if there are no questions, we would ask that the decision below be affirmed.
Thank you, counsel. Rebuttal, Mr. Ginzburg.
Thank you, Mr. Chief Justice. First, with respect to this case in particular, the record contains the only declaration from anyone on either side. And the declaration from my client, Mr. Daniel Beta, he said that he found out about the judgment in February of 2021. That is not contested in the record. And so with respect to what is a reasonable time, he did seek out counsel when he found out about the judgment. I believe the bankruptcy court should have taken that into account. With respect to my colleague's position that all of these cases kind of emanate from the D.C. Circuit's decision in Austin versus Smith, I respectfully disagree, because there's a long uninterrupted line of cases beginning in the early 19th century and going up through the 1938 enactment of the original rules of civil procedure, following the 1946 amendments, and really just a long line of cases, each of which held that a void judgment is in a special class by itself and cannot be barred by the passage of time alone. And lastly, preclusion and res judicata do exist, but those depend on an opportunity to be heard as well as notice. So for instance, if somebody were to file following judgment a Rule 60b-1 motion and not a Rule 60b-4 motion, certain courts have held that the 60b-4 motion is precluded because the litigant has already had an opportunity to make the argument. I would agree with that, except in the instance of that party not knowing that it has a 60b-4 argument. So if it does not know, so if it makes a 60b-1 argument without knowing that it also has a 60b-4 argument that the judgment is void for whatever reason, for instance, lack of subject matter jurisdiction due to a party not being diverse in a diversity case, then in that case I do believe that preclusion, the case cannot be, or the argument cannot be precluded, because there has to be an opportunity to be heard, and on a Rule 60b-4 argument, that judgment, if the person only finds out about that judgment at the time after filing the Rule 60b-1 motion, that litigant should have the opportunity to also make the 60b-4 argument, because that is when it found out about the judgment.
Thank you, counsel. The case is submitted. We'll hear argument next in Case 24-724, the Hain Celestial Group versus Palmquist. Ms. Harrington.
Thank you, Mr. Chief Justice, and may it please the Court. The Fifth Circuit erred in holding that it was required to vacate the district court's final judgment after determining that Whole Foods should have been dismissed. For nearly 200 years, this court has instructed that even if a federal court makes a jurisdictional error at the inception of a case, a final judgment in that case should stand if the district court had jurisdiction over the suit in the form it took at the time of final judgment. That is exactly what happened here, because the only parties left were completely diverse. Excuse me. Plaintiff's primary argument is that Whole Foods was a party in the district court through trial and to final judgment because the order dismissing it could have been, and eventually was, reversed on appeal. But if you accept that argument, that would wipe out the fraudulent joinder doctrine completely. In order to be a party in a suit, you have to be subject to the district court's jurisdiction. But when a nominal defendant is dismissed as fraudulently joined, that defendant is never subject to the jurisdiction of the federal court. The whole reason a fraudulent joinder case is even removable in the first place is because the fraudulently joined defendant is not treated as a real defendant. So if you view that dismissed defendant as a party through final judgment based on the possibility of reversal on appeal, then there would never be jurisdiction in a fraudulent joinder case, because even if the dismissal was later determined to be correct, the non-diverse defendant would have been lurking through the whole case to final judgment. Instead, when a defendant is dismissed as fraudulently joined, It's as if they never got in the door to the federal court in the first place, and the case moves forward as a suit between completely diverse parties. Here, the Fifth Circuit's later conclusion that the district court should not have dismissed Whole Foods didn't retroactively make Whole Foods a party all along. And because the only parties to the final judgment were completely diverse, many of this court's cases, including Caterpillar, instruct that that final judgment should be preserved. Finally, if this court harbors doubts that the district court had jurisdiction to enter a final judgment, the decision in Newman Green makes clear that the final judgment should be preserved by dismissing Whole Foods now. Either way, the Fifth Circuit's decision should be vacated, and I welcome the court's questions.
Can you think of a case where jurisdictional defect was cured non-consensually, that the court imposed a dismissal rather than the plaintiff consenting to it?
Well, in Caterpillar, the original plaintiff who objected to removal was not a party to the settlement that this court found cured the jurisdictional defect in that case. But I'd like to, if I can just address the concept of curing a jurisdictional defect, that is how this court has talked about it in cases like Caterpillar and Newman Green, and we picked up on that in the briefing. But when you're talking about fraudulent joinder, it might not even be the best framing, because when you're talking about fraudulent joinder, there isn't an erroneous assertion of jurisdiction ever in the way that there was in cases like Caterpillar, because the non-diverse defendant is just treated as not a real party to the case, and there's never an assertion of federal jurisdiction over the claim against that non-diverse party. And so here the question is, if you should have remanded a case to state court, and you didn't, but there was no assertion of federal jurisdiction over claims over which there was no jurisdiction, what do you do? And when there's no prejudice,
but there is an inherent prejudice, and that's the thing that you're ignoring, which is this plaintiff wanted to be in state court. It sued two parties, your client and Whole Foods. All right? It wanted to litigate. It couldn't because someone that it had a right to include, Whole Foods, was dismissed erroneously. It was deprived permanently of its opportunity, tactical opportunity, to try this in state court. Isn't that inherent prejudice?
I don't think it is, Justice Sotomayor.
Why?
Well, so first of all, it has the right still to pursue its claims against Whole Foods in
No,
state court.
but it wanted to apportion liability between two whole clients. Now it can't do that.
Well, it can't do that because it lost on the merits.
Oh, well, but the point is that it had a tactical advantage that was erroneously deprived of.
I don't think that's right, Justice Sotomayor. Being able to sue in state court isn't a tactical advantage.
Oh, absolutely. I mean, we wouldn't have all the removal arguments that we encounter if it wasn't. Parties don't fight removal simply because they want to. They see tactical advantages in remaining in one forum versus another.
Well, unless you're going to formally adopt a rule that state courts are always better for plaintiffs and federal courts are always better for defendants.
Not the point. No, the rule is very simply, this plaintiff filed in the forum it wanted. And it filed appropriately. It filed against a non-diverse defendant. It was entitled to stay in state court, and it wasn't required to drop a defendant that it didn't want to drop.
It is true that the case did not go the way that the plaintiffs wanted, but that's not enough for prejudice.
Well, yes, because what you're saying is it's prejudice to the court that you're looking at and not prejudice to the party affected.
Not at all. For it to be prejudice to a party, you need to have a material impairment to that party's ability to assert a claim or defend itself.
And I think we're going to have to stop there, because I do think suing the people you want to sue in the forum you want to sue them is a material disadvantage.
Do you think, Ms. Harrington, I mean, kind of picking up on Justice Sotomayor's point, it seems it's difficult for me to untangle here the problem of jurisdiction, which I kind of agree with you. I mean, if there wasn't a problem with diversity at the beginning and there was no problem with diversity at the end, and for reasons of efficiency, I mean, Caterpillar would not preclude your position. But there is a sense of unfairness, I think, to the plaintiffs, because they just never get the opportunity to appeal or to try to remedy this wrong, unless, I mean, is it just your position they have to try to get an interlocutory appeal at removal, and that's it? Otherwise, they just are out of luck?
Well, I think if the dismissed non-diverse defendant were an indispensable party, or somehow the absence of that defendant at the trial affected the outcome of the trial, then you might have an ability on appeal to get the judgment vacated and the whole thing sent back to state court. But here, the absence of Whole Food had literally no effect on the outcome of the trial.
But just to kind of put then a finer point on it, yes, you're saying there just isn't an opportunity to appeal it. In the same way, the defendant has a right of removal, but can't appeal a remand.
Right. Well, I mean, this court explained in Caterpillar that the rules, the way the rules are structured, it puts a premium on deciding very early in a removed case whether it should be in state court or federal court, and it tolerates some sort of errors, right? If a case is remanded to state court, that decision is never reviewable on appeal, no matter how wrong it was. Ordinarily, a plaintiff has 30 days to object to a removal on non-jurisdictional grounds. And if there's some reason they could have objected and they didn't object in the 30 days, it's too bad it's state.
So it's never reviewable unless there's some sort of prejudice, like a necessary and indispensable party.
Right, so it's not never reviewable, but you wouldn't correct it if you go all the way to final judgment and there was no jurisdictional problem through that time, unless the absence of that dismissed party somehow affected the outcome of the trial, yes.
What do we do about the fact that the problem here was created by your client through an improper removal? I mean, in terms of fairness, that your hands aren't exactly clean here. And what do we do about Lexicon, where it was two federal district courts? We weren't even talking about state court. And a judgment was entered, and there was no argument that the judgment in one district court's better than a judgment in another district court, and we completely sent it back to start over because the plaintiff's choice of forum was denied.
Well, it wasn't. I'll start with the second, if that's all right. In Lexicon,
let's start with the first.
Start with the first. Okay. I mean, it's not as if there's no argument that it was a frivolous argument, right? The district court agreed with us. The Fifth Circuit reversed. We accept that.
I'm not saying it was frivolous.
Right,
I mean, Rule 11, my goodness, I would never accuse you of that.
Thank you, Grant. Appreciate that.
However, the plaintiff's choice of forum was effectively denied through an improper removal by your client.
And that's exactly the argument that was made in Caterpillar. And this court said, the plaintiff says, look, if we let this happen, if we take an all's well that ends well approach, in the words of this court.
Well, it was fixed by the time of final judgment in Caterpillar.
Well, here it was too, I think. But if I can finish just the thought that they said, it will reward defendants for improper removal, and it will override the plaintiff's choice of forum. And the court said those are very important considerations, but they are overridden when you have a final judgment by principles of efficiency, economy.
All right, move on to the second one.
And finality. So for Lexicon, the problem there was that the problem hadn't been cured by the time of final judgment. The district court that entered the judgment never had the authority to do that. But here again, because the non-diverse defendant never really made it in the door to federal court, through the whole trial and at final judgment, there were only completely diverse parties. And so there's no lingering jurisdictional defect. There really never was a jurisdictional defect with this case in the district court.
Well, I guess that's a question. Last year we talked about 1367C in Royal Canin. And we talked about how 1367C says when you have a federal claim and a supplemental state claim and the federal claims drop out, that 1367C contemplates that the state claims, just those, there is still discretionary jurisdiction over them. Now, it's obvious that for various good and prudential reasons, the court should dismiss those a lot of the time, but not all of the time. The court, the court still has jurisdiction, supplemental jurisdiction over the state supplemental claims once the federal claims drop out. And the way Royal Canin talks about that is because the federal claims have not dropped out for good. They can reemerge on appeal. And because they're not gone for good, there remains jurisdiction over the state claims. And it seems to me there should be no different rule with respect to diversity, that even once one of the parties was dismissed, because that party still had the potential to get back into the suit and destroy complete diversity, in fact, the jurisdictional defect was not cured.
So the difference there is that when you have a federal claim that is dismissed by the court or somehow taken out of the case by the court, that is the federal court exercising jurisdiction over that claim. So that claim is in the case. When you have a non-diverse defendant dismissed as fraudulently joined, there is no exercise of jurisdiction over the claim from the plaintiffs to that non-diverse defendant, right? Because I think everyone agrees the district court doesn't have jurisdiction over the case if that claim is in the case. And so there's jurisdiction to determine jurisdiction always. And so the federal court says, I don't have jurisdiction over this defendant because it's not a real defendant and it's out of the case, and therefore I have jurisdiction over what remains, which is state law claims between completely diverse parties.
I think I'm missing it. In one case, the court says, I'm getting rid of these federal claims because you failed to state a claim, right? And in the other case, I'm getting rid of this party because the party's been fraudulently joined. And that produces a difference in outcomes such that there remains jurisdiction over the federal claims, but there doesn't remain jurisdiction over the remaining part, over the diversity suit?
Yes, because in the former, there's a merits determination as to the claims. There's an exercise of jurisdiction over those federal claims.
I mean, I get the idea that that's true. It's like, why should that difference make a difference? It's like, in both cases, the thing that created the federal jurisdiction is gone. And the question is, does the federal court still have jurisdiction over what remains? And what Royal Canin says is yes, because the thing that created federal jurisdiction can still come back.
So it is the opposite here, right? The thing that would have destroyed federal jurisdiction never gets in but never gets in the door. I mean, fraudulent joinder is a little bit of a weird doctrine, right? Because the only reason you can bring a fraudulent joinder case to federal court is on this fiction that one of the defendants isn't actually a defendant in the case, because if it were, there wouldn't be jurisdiction.
But Ms. Harrington, don't you have to be right about that in order to be able to rely on this argument? I mean, I think the problem is that to the extent the district court was wrong about the fraudulent joinder and that Whole Foods should have been in this case, then you do have a jurisdictional defect, which is non-diversity in a circumstance in which there should be. You have to have diversity in order to have federal jurisdiction. I don't know that you can just isolate that unless you're right. And the problem is you're not in this case.
Right. So great question, and I think you're wrong about the implications. And so you either would view the dismissed non-diverse defendant as out of the case, not a party, or as continuing to be a party. My friends on the other side want to say that's still a party because it might be reversed on appeal. If that's true, you can never have jurisdiction in a fraudulent joinder case because that jurisdiction—
No, you could have a situation where, as you urged in this case, the party could actually do an interlocutory appeal and get the final question as to whether or not this person should have been a party.
But my point is, even if the Fifth Circuit had gone our way and said, no, that Whole Foods was correctly dismissed, there wouldn't have been jurisdiction over the final judgment because under their view and under the view you're positing—
I get the idea. It's a little bit of a conundrum, but if in fact you're right and that there is a fraudulent joinder, doesn't that just get read back in to the situation that existed at final judgment?
I don't think so. I mean, the Fifth Circuit's decision, with all due respect to them, they don't have a time machine. They can't go back and change.
No, but that's the Caterpillar
happened.
situation. You would just concede at that point. I mean, you would cure it, right? So fine. Whole Foods was fraudulently joined, and we could continue to go on. But because you win in this situation, you would cure it.
No, but I mean, that would be Newman Green. In Caterpillar, the non-diverse defendant was already out of the case before final judgment was entered.
I understand, but the idea is that some jurisdictional defects can be cured by the time we get to final judgment. And Caterpillar, the cure was the person was actually settled out of the case permanently.
Yes.
And so we don't worry about the fact that previously in the case there might have been a jurisdictional problem. What I'm saying is that same solution would seem to me to be the answer to the conundrum that you're talking about with Justice Kagan.
I disagree, Justice Jackson. I think either a party is in a case or isn't in a case in the district court.
No, I understand, and that creates the defect, and the question is, can that be cured? And in the situation you're positing, maybe. Because by the time you get to final judgment, then perhaps the plaintiff would agree to the defect in this way, or agree to the cure, and then we'd be fine.
So, but I understood. I mean, what I was saying is that if the Fifth Circuit had decided on appeal that Whole Foods was correctly dismissed, that the fraudulent joinder ruling was correct, under the view you're positing where Whole Foods was a party all along, there still wouldn't have been jurisdiction to enter final judgment because Whole Foods wouldn't have been a party until it was affirmed on appeal that their dismissal was correct.
Ms. Harrington, I'm sorry, were you finished?
Nope, go ahead. Go ahead.
So you said at the beginning this would kind of destroy fraudulent joinder doctrine, and I take it that one of the reasons is this conundrum that you're discussing.
Yeah.
What about the incentives for people like your client who remove and then can't count on the fraudulent joinder dismissal? And then your client, I mean, would you want to remove if you thought you were at risk of investing all the resources in litigating the case to final judgment and then potentially losing it on appeal? I mean, what would it do to the doctor just from a matter of litigation incentives?
I mean, I think it creates strange incentives, but I'm not sure, I think defendants who think they have a right to remove will still remove. We assume good faith by parties. They're not going to assert a fraudulent joinder argument if they don't think it's valid, but it creates opportunity for a great deal of waste and sort of violence to principles of finality and economy, because nothing that happened in this case after the initial dismissal of Whole Foods involved any non-diverse party. There was 2 years of litigation, there was a trial, there was final judgment on the merits. All of that was among completely diverse parties. Whole Foods never got in the door. And so there's no reason to go back and say, well, we're just going to get rid of all of that and have a do-over, because the absence of Whole Foods didn't have any effect on the outcome. It didn't have any effect on what happened at trial. The plaintiffs could have sought third-party discovery against Whole Foods. They didn't. Whole Foods was barely even mentioned in the trial.
But can we go back to Justice Sotomayor's point about prejudice? So is it your view that there would be no potentially preclusive effect of this judgment on a subsequent determination or a subsequent trial related to Whole Foods? I mean, is your client not going to argue that Hain should lose that as well?
I mean, if that Hain should lose, I mean,
or that Whole Foods should lose.
So I think
Whole Foods, I mean,
right,
I sense a potential prejudice from having to try this twice when initially the plaintiff here wanted to bring one lawsuit against both of these defendants. And so I guess I'm asking, if we say it's okay to affirm the judgment with respect to this one defendant and it's fine because the plaintiff can go on to sue Whole Foods, is there any possibility of some kind of preclusion in the Whole Foods lawsuit?
So that's a question for state law that would need to be decided by the state court, I think. But even if the state court did say, yes, this determination that was made at the district court has preclusive effect with respect to the claims against Whole Foods, that wouldn't be prejudice.
Why not?
That's just the ordinary consequence of losing at trial, right? I mean, there's nothing about the absence
But we wanted to have one trial where both of these defendants were in there, and perhaps we wouldn't have lost under those circumstances.
But nothing about the absence of Whole Foods or the federal forum affected the outcome of the case. The district court judge, after hearing the plaintiff's entire case, said, you didn't present evidence of causation. The absence of Whole Foods had no effect on that. The federal forum had no effect on that. That's just a failure of proof by the plaintiffs. And so if it were determined in the state courts that having to live with that, with a preclusion effect, that's not prejudice, that's just what happens.
So is your rule turning on the actual judgment, whether it's about causation or whatnot? I mean, in a different case, let's say there was some implication of having another defendant in it. Would you have a different rule as to whether or not the judgment should be upheld?
Yes, if the absence of the dismissed defendant affects the outcome of the case, then I think the plaintiff would have a good argument that the judgment should be vacated and they should have a chance to start over in state court. But nothing like that happened here. The trial would have been exactly the same if Whole Foods has been there, and the outcome also would have been the same. But to pick up on one aspect of your question.
Are you saying sometimes vacature is the appropriate remedy?
If the absence of the dismissed defendant affected the outcome of the case or material
Portioning liability, things like that?
I mean, it could be with apportioning liability, but here there was no liability.
No, I understand that.
Yes.
So you're saying your rule is really case specific.
So as with any prejudice determination, it will depend on what actually happened in the case. My friends on the other side want you to think about prejudice sort of in the abstract with hypothetical parties, but you really have to look at whether there was prejudice to the parties in this case in these circumstances.
So there usually will be prejudice, or often prejudice, but just not here.
There could be prejudice. I mean, I would depend on the circumstances,
But then it's not really about jurisdiction, is it?
No,
if it's turning on prejudice, I mean, the court, normally we don't think of whether the court had jurisdiction or not as dependent on whether there's prejudice to a party.
Right, I'm talking, right, that's it. The question is like, what is the remedy for the fact that you should have been able to have these two defendants together, right? The automatic remedy when you should have been able to sue two defendants together, one was improperly dismissed, and you didn't, is not automatically to vacate the judgment for the other defendant. You would only do that if the absence of the dismissed defendant affected the outcome, affected that judgment. But where it didn't, there's no reason to vacate that.
I mean, it is a pretty awkward rule to say that a jurisdictional defect, the remedy for it depends upon prejudice in a particular showing. And again, we didn't do that in lexicon.
Well, I'll try one more time. There's no jurisdictional defect here once you get rid of the dismissed defendant.
I understand your point.
Right. And so the question is, if the error was separating these claims against the two different defendants, what is the remedy for that error? That's really what the error was here.
But you're treating it as, we separated two defendants improperly. But in fact, from the plaintiff's point of view, what the thing that went wrong is that the plaintiff is the master of her complaint. She clearly structured a suit in order to bring it in state court. That was why she joined these two parties, perfectly legitimately, in order to have the suit in state court rather than in federal court where it was. And the effect of this district court misjudgment was not that two parties were separated, is that the suit was tried in the wrong place from the plaintiff's point of view. And the plaintiff's point of view is the thing that should matter, because the plaintiff is the master of her complaint.
So I'll say a couple of things. It is true that the plaintiff is the master of her complaint, but that isn't a jurisdictional principle. That's sort of an overarching principle that guides federal.
It's an overarching principle of how litigation should work, and it also has a kind of equitable dimension, that you've deprived the plaintiff of an opportunity to do what our civil procedure system generally allows.
Yes, and exactly that argument was made in Caterpillar, and this court said that's an important principle, the plaintiff is the master of her complaint, but when you litigate a case to final judgment, it can be overridden by other principles of finality, efficiency, and economy.
Right. Now, that was a case where the court was absolutely certain that there was jurisdiction at the time of final judgment, and here there remains a question about whether there was jurisdiction at the time of final judgment.
No question in my mind.
Given the fact that that Whole Foods is lurking out there, ready to come back into the case if the district court got it wrong, as it did.
Well, again, I'd say to be a party in a case, you have to be under the district court has to exercise jurisdiction against you. And that never happened here. The district court made a prediction about what it thought state courts would do with the claims against Whole Foods and said, I don't think there's a valid claim, and dismissed. Right? The plaintiffs can, in most cases, can then go pursue those claims in the state court if they wish. There's never any exercise of federal jurisdiction over that non-diverse defendant. And so then the whole case proceeds between completely diverse parties, including the entry of final judgment. So I don't think there's a real question about whether, the way this court has phrased it is whether the district court would have had jurisdiction over the case in the form it took at the time of final judgment. And there's really no question that certainly was true here, that the district court had jurisdiction over the case in the form it took at final judgment. And again, if you view Whole Foods as having lurked through the case the whole time, then you really couldn't ever have fraudulent joinder removal, because there would never be jurisdiction to enter final judgment until the dismissal of that non-diverse defendant was later affirmed on appeal.
Couldn't it be affirmed interlocutorally? Those kinds of judgments can be appealed in the middle of the case, correct?
So they could, and you could, if a plaintiff were worried that the dismissed defendant was somehow indispensable, they could seek a Rule 54B judgment or 1292B. But
in that case, we wouldn't have to wait until the final judgment. We would get the answer as to whether or not the party should have been in there, and then the case would go forward.
Yes, but you shouldn't. But requiring that in every fraudulent joinder case should not be the rule. In the same way that this court in Caterpillar said we shouldn't require 1292B.
I mean, we're not requiring it. It's just the parties are taking risks. Everybody's strategic here and making determinations about what is worth pursuing. You can have an interlocutory appeal. You cannot. You can wait. You cannot. But you're taking a risk that when you get to the end of the case, this jurisdictional defect will be realized and not cured, and you might suffer.
If you adopt that approach, it would slow down every fraudulent joinder removal, and it might not actually solve the problem for the reasons given in our brief. I see the red lights on.
Thank you, counsel. Anything further? No? Thank you. Mr. Post?
Mr. Chief Justice, and may it please the Court. The question in this case is whether a federal court can acquire jurisdiction through error. If the case is decided according to the first principles of federal jurisdiction and the rationale of Royal Canin, to which the Court has referred this morning, the answer must be no. Federal courts are courts of limited jurisdiction, and the obligation to respect those limits is inflexible and without exception. The Court should not make an exception to the party-neutral rules that Congress has established for a case where a plaintiff maintained a valid state law claim against a non-diverse defendant through final judgment. Appeals to judicial efficiency have never been a reason to ignore the limited jurisdiction of the federal courts, and Caterpillar confirms that conclusion. It held that vacatur was not required only because the lack of complete diversity in that case was cured by the voluntary dismissal of the non-diverse defendant prior to final judgment. And that cure was reinforced by a Rule 54B partial final judgment that eliminated any jurisdictional uncertainty. Here, unlike in Caterpillar, the defect was never cured. That's the crux of this case. The Court should hold that an erroneous and involuntary dismissal of a non-diverse defendant does not create complete diversity because jurisdiction cannot be created through error. Finally, contrary to the argument that you've heard this morning, that proposition is perfectly consistent with the Court's fraudulent joinder jurisprudence. An interlocutory ruling that a party was fraudulently joined is effective while it remains in force, and the citizenship of that party is disregarded. But the party remains in the case, and the ruling, like any other pretrial ruling, remains subject to appellate review. If the ruling is upheld, then complete diversity is intact. But if it is reversed, then complete diversity is lacking and the judgment must be vacated. That's exactly the same as the core rationale of Royal Canin earlier this year, and it should control this case. I welcome the Court's questions.
This would be a lot cleaner case if you had appealed the dismissal. Why didn't you?
Your Honor, because the Court held in Caterpillar that there's no obligation to seek immediate review to preserve the right to an ultimate appeal on this issue. This is no different than any other threshold jurisdictional issue that arises and is preserved. This most frequently arises when a defendant wants to preserve an objection, for example, to Article 3 jurisdiction based on a standing objection. Those types of issues are frequently preserved early in litigation and are not ultimately vindicated until the end of the appeal for a final judgment. That's sort of inherent in the doctrine that appellate review is ordinarily deferred until after final judgment under this Court's merger rule.
District courts still retain.
I'm sorry, Your Honor?
District courts still retain the power to certify without the request of either party.
Absolutely.
So if any court is worried, they could enter a 54B.
That's absolutely right, Your Honor. And in fact, I would point out that in 1980 in the Curtis Wright decision, this Court held that one of the guiding principles for district courts is the consideration of judicial administrative interest. That's what should guide a court in making that determination. And so if there's concerns about uncertainty about jurisdiction and potential waste, Rule 54B is the resolution for that sort of concern. District court could have pursued it here. The defendants could have requested it to resolve the uncertainty, but they elected not to do so.
But you could too, and your position was that you were standing on Caterpillar. I mean, Caterpillar does not answer this question clearly one way or another. So, I mean, that makes it seem like your choice was to take a wait-and-see approach and then decide whether you liked the result or not before you chose to fight it.
That's not correct, Your Honor. I do want to confirm the principal point that the Court made. Caterpillar does not resolve this question, as the petitioners acknowledge in their reply brief, because it recognizes that if the jurisdictional defect remains uncured at final judgment, vacatur is required.
It doesn't resolve. I mean, let's see. There are different ways to, but it doesn't resolve the question. So my point for this purposes of this question is solely that you're saying that you were standing on a case that doesn't squarely resolve the question, and that's why you didn't try to seek an interlocutory appeal?
Not, Your Honor, with respect to the preservation holding. Caterpillar does squarely resolve the question of preservation, that a party that raises the objection to jurisdiction has done all that is necessary to preserve the right to an ultimate appeal. Again, that's a party-neutral rule that flows from the final judgment rule. It's just the same principle that applies when a defendant objects to jurisdiction at the outset of the case. There's not an obligation to take an immediate appeal in order to vindicate that.
What do you think that?
I was just going to say, your question is, why didn't you appeal?
Right, but that, I mean, whatever, we'll just let that go. What is your answer to the questions about preclusion that Justice Jackson was asking you earlier? What would happen in state court? Do you think you would be, barred by non-mutual issue preclusion from relitigating some of these issues?
That is a controversial question. We certainly would not concede that preclusion would lie here. I would argue that there may be exceptions under state law, both because of the nature of the jurisdictional ruling in the first instance and because there could be differences in sufficiency evaluation under state law as opposed to federal law. But all of that presupposes that the jurisdictional problem could be cured and that judgment could actually have any substance on the merits, which I think is incorrect. I do want to speak directly to the court's question. The reason that there was not an immediate appeal taken was not only that the plaintiffs were relying on their right to seek review after final judgment, but as a practical matter in litigation, litigants make their best arguments, they preserve their positions, they respect the rulings, and they move forward. And our clients moved forward to litigate the case on the merits as best they could with respect for the district court's ruling.
What about prejudice, though? One of the reasons why I brought up preclusion was because there was an argument that given that Whole Foods was not actually part of this litigation, that you are not prejudiced by having to sue them in state court separately.
Well, Your Honor, of course, prejudice is not a material consideration where we're dealing with the first principles of limited federal jurisdiction. And so I think principally the plaintiffs do not have to demonstrate prejudice to satisfy the court that there's a lack of jurisdiction in this instance. But it certainly is the case that the plaintiff, as the court has indicated, is the master of the complaint. And that is a jurisdictional principle, contrary to what counsel said. The right of the plaintiff to configure the case for purposes of litigation is a function of the congressional scheme that makes jurisdiction turn on the claims and the parties.
I don't think you're answering Justice Jackson's question, though. I have the same one, right? Aren't you asking whether the judgment was, I mean, how did it hurt your client that Whole Foods wasn't in the case when, your friend on the other side is pointing out that nothing in the case turned on Whole Foods or its evidence? Put aside the jurisdictional point for now.
And I appreciate the point. My point was simply to be that the lack of the state forum in a single proceeding in which both defendants could be brought within the same proceeding is itself prejudicial.
So I take it it's a very abstract prejudice in the same way that your friend on the other side said it's abstract. It didn't really affect the outcome. You're not saying the outcome would have been different. You can't point to anything like that.
That's the jurisdictional principle. That's right, Your Honor. With respect to practical prejudice, as a practical matter, the way this case was litigated with Whole Foods out of the case, there was no opportunity for the plaintiffs to develop the evidence that they would have developed about the role of Whole Foods in actually making express misrepresentations about the quality of the baby food at issue. And so it is true that as the case was tried, it was tried solely based on the quality of the product. But that was an artifact of the erroneous ruling, an erroneous eerie guess made by the district court about the content of state law that should have been a determination made by the state courts consistent with the congressional scheme.
I'm sorry, you lost on causation, meaning I thought you lost on first principle, which is that even if there was toxic substances, they didn't cause this condition.
Your Honor, there's a dispute about the accuracy of that ruling. That's correct. The district court found that there was a failure of proof of causation.
Well, you lost that on appeal, so it's gone.
We did not, Your Honor. That question was never decided by the Fifth Circuit. It would remain to be decided.
I see.
And our position is that the proof that was put forward at trial is sufficient.
Okay, counsel, your answer.
Thank you, Your Honor.
Well, you made a reference to the possibility that the standard for judgment as a matter of law might be different in Texas, in the Texas courts than in the federal courts, or did I misunderstand what you said?
Your Honor, I think that's a possibility. I think if it were necessary to litigate the preclusion question in a state court proceeding, then it would be necessary to determine whether the legal rule that was applied in the federal courts, if in fact one assumed the Fifth Circuit upheld judgment as a matter of law, was applying the same standard for sufficiency that the state courts would apply. That's not a question that the parties have developed because to this point we've clashed on the merits only under the Fifth Circuit's precedent. I want to pick up the point that Justice Kagan made regarding Royal Canin and Section 1367C3 because it's not a point that was explored in the briefing, but I do think it is powerful. Because the holding of Royal Canin, of course, is that a plaintiff's voluntary amendment that abandons a federal question claim completely deprives the court of original jurisdiction and therefore deprives it of discretion to entertain a supplemental jurisdiction claim under state law claims. The necessary premise of that is that where 1367(3) states that otherwise a federal court that dismisses the original jurisdiction claim may retain jurisdiction over the state law claims, is that if the federal court has involuntarily dismissed the claim, it doesn't lose jurisdictional significance. That claim, although dismissed in an interlocutory posture, retains its jurisdictional significance for purposes of original jurisdiction.
So I heard Ms. Harrington make 2 points with respect to that point. One was that it's different when the district court does it on the merits and has asserted jurisdiction over the suit when that decision happens. And the second is that if we applied the same rule here, we would have a real problem with any fraudulent joinder case because you could never say that at the time of judgment there was in fact jurisdiction.
Your Honor, if I may, I'll speak to the second point first. And I think that that's just a false understanding of fraudulent joinder doctrine, and there's no principal way to draw the distinction that the petitioners are trying to draw. And I would call the court's attention to 2 of your decisions that I think illustrate the point that I've made, which is that when a party is found to have been fraudulently joined by a district court, its citizenship is disregarded, but it doesn't cease to be a party to the litigation. That remains subject to appellate review. So 2 cases the court should consider. The first is the kettle hockey case, which is discussed in our brief. That's one of the cases from the voluntary-involuntary line of authority. And in that case, the state court not only found that there was no viable claim against the nondiverse defendant, but under state procedure ordered a involuntary non-suit, and so separated formally that party from the litigation. And this court held, when the question reached this court, that involuntary non-suit did not so terminate the party's significance from the case that it resolved a jurisdictional issue. The second case that I would call to the court's attention, which isn't discussed in the briefing, is Mecom versus Fitzsimmons. It's 284 U.S. 183, a 1931 decision by this court, in which this court reversed a fraudulent joinder ruling. And the necessary premise of that is that that party remained in the case until it arrived here for this court to reverse the ruling. The party didn't disappear immediately. As a practical matter, Whole Foods has been in this case from day one. They are here today. Their counsel is sitting here at counsel table because they are a party to this litigation. You can't pretend otherwise.
That was one of Justice Kagan's points. Was there another one?
Your Honor, I think the first point was that there's a distinction to be drawn between a merits-based disposition and a jurisdictional disposition. I don't know that that's a stable distinction in principle, but certainly when you're dealing with fraudulent joinder, for which the question is whether there's a reasonable basis for the claim, the substance of the analysis merges. And so a federal district court's interlocutory determination to dismiss a federal question claim has the same consequence as its interlocutory determination that there's fraudulent joinder. The party still remains in the litigation subject to appellate review, and therefore the jurisdictional issue is not cured.
Thank you, counsel.
Thank you, Your Honor.
Rebuttal, Ms. Harrington.
Thank you, Mr. Chief Justice. Just 5 quick points. First, on the point that we know that Whole Foods is still a party because they're sitting here with us at counsel table, as they are, there are other circumstances in which a person or a company can be a party to an appeal without having been a party at the trial. So, for example, if a plaintiff asked for permission to add another defendant under Rule 20 and the district court says no, the plaintiff can appeal that denial on appeal from final judgment, and the person who was never added, the defendant, would be a party to the appeal, but never having been a party to the district court. And there are other examples. So I would ask you to reject that argument. To circle back to Justice Gorsuch's question about including prejudice in a jurisdictional inquiry, I just want to try to clarify, it's not that you would think about prejudice in deciding whether there was or wasn't jurisdiction. It's more that you would say there was jurisdiction, and then you ask, did the absence of the dismissed party affect the outcome? And there's where the prejudice comes in. The third point is just on whether the absence of Whole Foods affected the outcome. My friend said, well, we would have developed all this evidence about what Whole Foods said. As Justice Sotomayor said, they lost on causation. It doesn't matter what Whole Foods said or didn't say. If you can't prove causation, you can't prove any of your claims in this case. On the master of the complaint principle being jurisdictional, this court rejected that view implicitly in Caterpillar. They said, it's an important principle, but it gives way to principles of finality and economy. And on the final point, I want to say it's not just me saying that things change after final judgment is entered. That's also written into Section 28 U.S.C. 1447C, where Congress has said if you realize district court before you enter a final judgment that you lack jurisdiction, you should send it back. But implicitly, then things change after final judgment. And also this court's case in Newman Green recognized that courts of appeals can dismiss a lingering non-diverse party after final judgment in order to preserve final judgment. The Court of Appeals clearly at least had that authority here, and its ruling that it was required to vacate the final judgment was plainly incorrect, and so we would ask the court to reverse. Thank you.
Thank you, counsel. The case is submitted.
The Honorable Court is now adjourned until tomorrow at 10 o'clock. Civil procedure is my new favorite field. That's funny. What you did to celebrate? Not really anything.